Mr. Muiwa, you are there? Mr. Muiwa, register, restart your device. Shalewa,
Yes,
can
my
you
lord.
right? Can you ensure that all councils have their proper names? And if there are
Yes, my
parties,
lord.
can we know who they are so that we know those online?
Yes, my lord. Good afternoon, councils. Please
Good afternoon.
unmute yourself. Yes. Please,
Good
can we
afternoon.
know? Yes. Please name your proper name, please.
My name is
And your
Stephen Azubike. My name is Stephen Azubike. I am counsel
okay.
to the petitioner in the case of Oluwatosina Araba versus Ivan Bulem.
Okay. Where are you presently?
I am presently in my house.
Okay. Okay. Council, good afternoon. Council.
Good afternoon. Yes, ma'am.
Yes.
Good afternoon.
Yes.
Yes, ma'am.
Okay. Please, we want your name to be properly named.
Yes,
Your proper name.
Shea Demer. Shea
Yes.
Demeran.
Yes, your location, please.
Lagos.
Okay. Which of the matter are you in, please?
Number 4. Nkechi
Okay.
Edebiatu versus Ubaka Edebiatu.
Okay. Okay. Council, good afternoon.
Yeah.
Good afternoon.
Yes, please. Okay. Which matter are you in, please?
First matter on the list.
Sorry?
The first matter on the list, Mutiu Shueton,
Oh,
HTC
okay.
33. Yes.
Okay. Your name, please.
OS Akola Wale.
Okay. Yes, Akola Role. Okay. Your
For the
location,
claimant,
please.
Alta.
Okay.
Okay, Registrar. 1 minute, please. Registrar,
Yes, my lord.
I think we can start. Can we start with the first case?
As a couple, please, sir. My lord, number 1 on the first is, sir. ACT 33-2013. Mr. Mutiu Shoeton. Mr. Waliu Shoeton. Mr. Aziz Shoeton. Mr. Sikiru Shoeton. Mrs. Shakirat Shoeton Babatunde. Mrs. Kudirat Shoeton Suleiman. Chief Nasiru Dende. Chief Wadudu Dende. Mr. Azim Dende. Mr. Gbadebo Bello. Mr. Ebelamu Taiwo. Mr. Dolapo Dende. Mr. Oyegbola Adeniji. Alhaji Olusoji Olushesi. Mr. Afisu Salaudeen. Mr. Ganiyu Alabi. My lord, parties are absent, sir.
Parties absent?
Yes, my lord.
1 minute, please. Representation in the case of Shoeton and Dende.
It please, my noble lord. My name is O.S. Akolawole. I appear for the claimants, my lord. I apologize that the claimants are not able to join this meeting, my lord. I apologize for the absence.
1 minute, please.
Great to me, lord.
One minute, I'll be with you in a minute.
Let's copy this.
Yes.
OS Akolawole for the claimants. Any other representation? Any other representation in this suit? None?
None, my
No,
lord.
ma.
Mr.
Lord.
Akolawole, where are you logging in from? Your
From
location
Ota.
today?
I'm presently in Ota, my lord. Ota, Ogun State, my lord.
Right. Right. Judgment in the case of Shueton and Dende.
Let's copy this.
The claimants filed a suit at the Ota Judicial Division against the defendants on the 1st of February 2013, seeking the following reliefs. Shalewa, please let me know if there is anyone in the waiting room. You have to
Yes,
look actively.
Yes,
do
my
you
lord.
know how to admit people so I can make you co-host?
Yes, my lord.
Okay, so I am going to make you co-host so that you can admit anyone in the okay. I think I'm already a co-host on the other one, so I don't know if I can have more than one co-host. Let me know anyway if there's someone in the waiting room.
Yes, my lord.
A declaration that the claimants are entitled to the statutory right of occupancy over a plot of land situated at Idiroko Road, Iyanoyesi, Ilupeju Ota, as described in Survey Plan LAKS OG 94306, dated 21st August 1994, prepared by Surveyor OK Oluokun, registered surveyor. The sum of 775,500 as special damages for items and materials destroyed on the land by the defendants. The sum of 250,000 naira as general damages for trespass committed on the land by the defendants. An order of perpetual injunction restraining the defendants, their servants, privys, and agents from committing further acts of trespass on the land in dispute. I hope parties can see me well. I hope I'm within the camera view, registrar.
Yes.
Yes,
Okay. The following pleadings were filed by the parties. The statement of claim dated 1st February 2013 on pages 4 to 23. Statement of defense of the first defendant dated 29th July 2013 and filed on the 30th of July 2013 on pages 101 to 104. Statement of defense of the third defendant dated and filed 31st of January 2014 on pages 114 to 117. Statement of defense of the fourth defendant dated 20th of March 2013 and filed on the 21st of March 2013 on pages 89 to 93. The third defendant's amended statement of defense dated and filed 17th April 2015 on pages 212 to 218 of the case file. Amended statement of claim dated and filed 20th July 2016 on pages 300 to 306. Third defendant's second amended statement of defense dated and filed 31st January 2020 on pages 428 to 432. Statement of claim dated and filed on 3rd May 2024 on pages 538 to 544. The extant pleadings in this suit are the further amended statement of claim dated and filed 3rd May 2024, amended pursuant to the order of the court on the 25th of May 2023 on pages 538 to 544. Statement of defense of the first defendant dated 29 July 2013 and filed on the 30th of July 2013 on pages 101 to 104. Third defendant's second amended statement of defense filed 31st January 2020 on pages 428 to 432. Fourth defendant's amended statement of defense dated 20th March 2013 and filed on the 21st of March 2013 on pages 89 to 93. At the trial of the suit, the following witnesses were called. Mr. Aino Saeed as CW1, who testified on the 17th of May 2018. Mr. Mutiu Shoeton as CW2, who testified on the 10th of April 2019 and the 11th of June 2019. Alhaji Azim Dende as DW3, who testified on the 4th of March 2021. One minute, please. At the trial of the suit, the following, yes, I have the following exhibits were attended. Survey plan number LAKS OG 94306, dated 21st of August 1994 as Exhibit CW 2A. Deed of agreement of the 11th of February 1987 between Falola Taiwo, Bello, and Shoeton as CW2B. Receipt of booklet as CW2C. Letter dated 25th January 2013, admitted as CW32D. And is the letter to Alhaji Chief Nasiruddin signed by A.N. Akipelu. Another letter dated 25th January 2013 to Alhaji Olusoji Olushesi signed by A.N. Akipelu, admitted as CW2E. Letter dated 25th January 2013 to Alhaji Dauda and Co, signed by Abayomi Fabayi, admitted as CW2F. Affidavit of Mr. Kola Dende in suit ACT 3313, Mutiu Shoeton and Nasiru Dende, admitted as CW2G. Olagbayi land receipt dated 6 June 2003, admitted as CW2H. Igbojo family land receipt dated 8 April 2009, admitted as CW2I. Igbojo family land receipt dated 5th September 2007, admitted as CW2J. Postal service receipt admitted as DW3A125. Handwritten letter dated 24th June 1990. Admitted. Is anyone in the waiting room, Shadiwa? Admitted.
No, my lord.
Right. DW3C, that is after the handwritten letter of the 24th of June 1990, which is DW3B. The letter of the 11th of February 1992 by A.A. Dinde is admitted as DW3C. The letter of the 13th of December 1989 to Hong Kong Synthetic Fiber Co. is admitted as DW3D. Copy of deed of agreement dated 11th February 1982, admitted as DW3E. Ariku Akongo Chieftaincy Family Purchase Lease Receipt, admitted as DW3F. The claimant's case. The claimant's first witness, Saeed Aino, CW1, adopted a statement on oath dated 1st February 2013, documented on pages 14 to 21. He testified that he knows all the parties involved except the 11th defendant. CW1 stated that the property in dispute was sold to the claimant's father, the late Alhaji Fatai Ashiri Abu Shoeton, by the Ariku Akongo family. He also testified that his family, the Olagbayi Igbojo family collected 200,000 from the claimants as ratification of title fee, which was paid directly to the head of family, Alhaji Olusoji Olushesi, the 8th defendant. CW1 testified that the claimant's father erected 7 shops on the property in 1994 before his death in 1995. Additionally, he mentioned that the Olagbaji Igbojo family collected money for the foundation laying when the claimant's father constructed 10 blocks, making a total of 17 shops. He stated that 10 blocks of shops, sorry. He stated that the 3rd, 6th, 7th, 8th, and 9th defendants led thirds to the disputed property and demolished 10 newly erected shops and were still determined to demolish the other shops on the property. He confirmed that the disputed property legitimately belongs to the claimants and denied any involvement of any member of the Olagbaji Igbojo family in the forceful acquisition and demolition of the claimant's property. Under cross-examination, CW1 stated that he is a principal member of the Olagbayi Igbojo family and clarified that there is no difference between Olagbayi and Igbojo family, as family receipts can be issued in either name. He insisted that the Olagbayi Igbojo family owns the land, not the Ariku Akongbo family. CW1 affirmed that he was aware of the foundation construction for 10 shops in 2013 and that Mutiu Shoeton gave him foundation money and settled him. He maintained that Mutiu Shoeton's father built the initial 7 shops, although he was not present when they were constructed. CW1 admitted that the land had been sold to the claimant's family by the Ariku family before 2013, which is why they collected money from the claimants in settlement. CW1 acknowledged that there has been disputes over the property before 2013, but they were resolved. He also admitted that there is a mosque near the disputed land owned by the Idota family and confirmed that he is not a member of the Idota family. The second claimant's witness, Mutiu Kayode Shoeton CW2, adopted his further statement on oath of the 20th of July 2016, which is documented on pages 307 to 312. He confirmed his role as the first claimant in the current case filed on behalf of the entire members of the late Alhaji Fatai Ashiriabu Shoeton family. He testified that the claimants are the direct children of the late Alhaji Fatai Ashiriabu Shoeton. CW2 identified the first 7 defendants as principal members of the Ariku Akongbo family sued both personally and on behalf of their entire family from Ocha. The 8th and 9th defendants are head and secretary of the Olagbayi Igbojo family, also sued personally and on behalf of the entire family from Ocha. The 10th defendant is the agent involved in the alleged sale and purchase of the disputed property, whilst the 11th defendant is the purchaser who purportedly bought the property in question. He described the disputed property as a plot of land along Diroko Yano Yesi Lupeju Ota, detailed in Survey Plan LAKS OG 94306, dated 21st August 1994, and prepared by Surveyor OK Oluokun. The property includes 17 blocks of shops. CW2 testified that in the late 80s, the late Alhaji Fatai Ashiriabu Shoeton purchased the land from the Agongo family, formalized through the purchase agreement dated 11th February 1987, prepared by Olufemi Ojugbele Esquire, now His Royal Highness Yonilobo of Ilobo. The agreement was duly executed and stamped by the appropriate authority. CW2 stated that his father took possession by surveying the land and erecting 7 shops, which had been occupied by the tenants since 1984. CW2 further testified that their father died on the 6th of August 1995, leaving behind his children, wives, and dependents who have been supported by the income from the shops on the disputed land. He claimed that the property naturally devolved to the claimants as beneficial owners. In 2009, the Olagbayi Igbojo family, represented by the 8th and 9th defendants, approached the Shoeton family, claiming the land was part of their family land. The claimants paid 200,000 ratification fees with receipt dated 8 April 2009, signed by the 8th defendant Additional payments of 40,000 were made on 2 occasions with receipts dated 6 June 2003 and 8 September 2007. CW2 testified that due to threats of forceful acquisition by the defendants, the claimants, despite financial constraints, constructed 10 additional shops to deter trespassers. These shops were at lintel level before being destroyed by the defendants. The claimants enjoyed peaceful ownership until January 22, 2013, when thugs led by the 3rd, 5th, 6th, and 7th defendants invaded the property, forcefully evicted the occupants, and destroyed 10 newly constructed shops, an office apartment with 4 rooms, and a big cage with poultry food fenced with roofing sheets. CW2 claimed investigations revealed that the 10th defendant acted as the agent for the 11th defendant in purchasing the disputed property, and the 3rd defendant, Mr. Azim Dende, along with Dolapo Dende and Oyebola Adeniyi, masterminded the plan to seize the property. He further stated that the 2nd to the 7th defendants allegedly shared 10 million as the purchase price of the property. The claimant solicitors, Messrs. Ali Daudu and Co., wrote to Chief Nasiru Dende and Alhaji Olushesi, the 1st and the 8th defendants, on January 25, 2011, reporting the trespassing activities. In response, the 1st defendant denied knowledge, consent, or approval of the forceful occupation. CW2 also testified that thugs armed with dangerous weapons mobilized by the defendants who covered the property with roofing sheets and destroyed the newly constructed shops. The petition was, CW2 testified that thugs armed with dangerous weapons mobilized by the defendants covered the property with roofing sheets and destroyed the newly constructed shops. A petition to the police at Alagmo led to CW2 and the 4th claimant's arrest on the 31st of January 2013, and they were only released after their solicitors intervened the following day. CW2 provided particulars of the items and materials destroyed, which have been stated as 300 units of block, 50 bags of cement, bricklayer's fees, 2 water tanks of 50 liters, soft sand, 2 tipper load of sand, gravel, 2 tipper loads, all totaling 775,000. CW2 testified that they do not intend to sell, let, or lease the property to the defendants or anyone else. He also mentioned that the secretary of the Agombo family, Mr. Kola Dende, approached the claimants for amicable settlement of this matter because the 3rd defendant is his brother. The claimant's counsel refused the settlement due to professional ethics. Under cross-examination, CW2 admitted that the agreement with the Ariku Akombu family was prepared in 1987 and that his father died in 1995. He stated that he was 22 years old when his father died in 1995. He admitted that they purchased the disputed land from the Olagbayi Igbojo family because they claimed to have judgment over Ariku family, though it was not shown a copy of the judgment. CW2 acknowledged that he was young when Exhibit CW2B was executed, but he insisted he was above 14 years of age at that time. The defense case. The 3rd defendant, Azim Dende, DW, who I have named as DW3, testified on oath and adopted its further and better statement on oath of the 31st of January 2020, documented on pages 433 to 436 of the case file. DW3 claimed it is an accredited representative of the Ariku Agombo family and has been its secretary since December 1987. He testified that all family documents and records are in his custody. DW3 mentioned that the post office number of all Ariku Agbobo family purchase receipt, his personal post office number. He stated that the Olagbayi Igbojo family do not have any landed property within the vicinity of the Ariku-Akongo land, as they were customary tenants of the Ariku-Akongo family. He added that the 10th defendant was never employed as an agent or attorney of the Ariku-Akongo family. DW3 claimed that the claimants did not construct anything on the land and that Fataya Shiriabu Shweton did not purchase any land from the accredited representatives of the Ariku Agbobo family. He stated that any sale of land requires 5 signatories for validity. He detailed the structure of the Agbobo chieftaincy family, consisting of the Oguntoye Agbobo family and the Ariku Agbobo family, and explained the internal family politics following the death of Adeyeye from the Oguntoye stock in 1987. DW3 contested the validity of the purported sale of Ariku Agbobo family land to the claimants, arguing that it was conducted without the consent and authority of the head and principal members of the Ariku Agbobo family. He pointed out that Chief Dende was the head of the family in February 1987, not Musediku Ogungbayi Falola, who only became the head of the family in December 1987. Under cross-examination by the 4th Defendant's Counsel, DW3 admitted that the 4th defendant is a principal member of the Ariku Agbobo family and that the Ariku Agbobo family and the Agbobo family are the same. He confirmed knowing Kola Dende and denied that Kola Dende was appointed as the family secretary in 1989. He admitted to selling the disputed land to Mrs. Famuyiwa in 2012 during a family crisis with no head of family. He confirmed engaging Aki Folarin to write letters on his behalf and acknowledged knowing Mr. Kola Dende, his older brother from the same mother, who swore to an affidavit on the 1st of February 2013. He also admitted knowing Musediku Falola, head of the Agbobo family in 1998, who died around the year 2000. DW3 admitted knowing Chief Nasiru Dende, the 1st defendant, and acknowledged the statement of defense filed by him. He confirmed knowing Mr. Ebelamu Taiwo, a family member, and negotiating with Mrs. Famuyiwa regarding repayment related to the disputed land. He insisted that 3 family members sold the land to Mrs. Famuyiwa, but denied that Kola Dende was one of them. He acknowledged that Fasasi, Karim, Madam Alake Dada, and Chief Ebelamu were signatories to DW3D and admitted signing DW3C as A Dende. He denied writing any petition against Shweton, the 1st claimant, and claimed ignorance of Shweton's detention in Alagbon. Due to the absence of the defendants and their inability to conclude their case, the case was closed on the 6th of February 2024, and parties were ordered to file written addresses. Only the claimant complied with the court's order. The claimant filed his written address on the 3rd of May 2024 and adopted his submissions as arguments before the court on the 13th of May 2004. As the defendants refused to comply with the court's order to file their written address, the claimant raised one issue for determination: whether from the material facts and evidence presented by the parties before the court, the claimants are entitled to the reliefs being sought by them from the Honorable Court. The court adopts the only issue raised by the claimants as sufficient to determine the case: identity of the land. The identity of the land is well described as a plot of land situated along Idiroko Iyano Yesi Ilupechu, more particularly described and delineated in Survey Plan LAKS OG 94306, dated the 21st of August 1994, prepared by Surveyor O.K. Oluokun, registered surveyor. I agree with the submission of counsel for the claimants in paragraph 4.03 of the written address that the identity of the land in dispute must be well established and defined. In this case, there is no dispute as to the identity of the land in dispute, as both parties know the land in question, and the defendants have not raised any issue regarding the identity of the land in their pleadings. The defendants have not disputed the area or location of the land, therefore there is no issue as to the identity of the land. See Anyawali and Udusomi citation provided. Evidence of DW3. Learned counsel for the claimants has urged the court to expunge from the records the evidence of DW3 being the only witness for the defendants. However, before the court granted this order for the witness to be recalled, evidence had been given by DW3 and cross-examination had been conducted. Therefore, I do not think the argument of counsel to expunge the evidence of DW3 will be allowed in the circumstance. See Ginodo and the state citation provided. Since the witness had been cross-examined in the first instance, I do not see the need to expunge the evidence of DW3. And proof of title to land. In actions for declaration of title, there are 5 ways of proving title as stated in Idumdum and Okumagba. That is by traditional evidence, by production of documents of title, which are duly authenticated, by act of selling, leasing, renting any or parts of the land or farming on it, by acts of long possession, long enjoyment and possession of the land, by proof of possession of connected or adjacent land in circumstances which render it probable that the owner of such land would also be owner of the disputed land. The claimant must rely on the strength of their case and not on the weakness of the defendant's case. See Newman Olodo and Chief Bortins Josiah, citation provided. See also Commissioner of Lands, Midwestern States, and Francis Edo Osage, citation also provided. The claimant relies on documentary evidence and acts of long possession to prove their case, as evidenced by the testimony of the claimants and exhibits CW2A to J to CW2J. Production
Oh my God, network. It is from their side.
I think I lost connection. I'm trying to get back on the other device.
Okay, man. Okay, your worship. Your lordship.
I
I'm in the court. I don't understand. you don't know what I'm signing. I want to type right. Where would you type? Let me give you my system. Type on my system.
Mr. Lanrewaju, please, can you unmute yourself, please?
Oh.
Right. Sorry for that glitch. I lost connection. Where are we now? Additionally, long possession alone will not confer title if another person has a better title, but will defeat a claim of title that is not proven. Can you see me? Okay. Am I within camera view?
Yes, my lord.
Okay. See the case of Mascala and Seeley, citation provided. The evidence must show possession that is consistent with ownership. See Mortgagee and Cadbury, citation also provided. Now, the claimant's case, Aina Saeed, the principal member of the Olagbayi Ogbojo family, testified to the possession of the premises by the claimant's father and the ratification payment in 1997. It confirmed the destruction of 10 shops built by the claimants by the 3rd, 6th, 7th, 8th, and 9th defendants. The defendants did not defend the suit or controvert the facts. The first claimant, Mutiu Shueton, testified that their late father, Alhaji Fatai Ashiri Abu Shueton, the defendants, except the third defendant, did not give evidence. The first claimant, Mr. Mutiu Shueton, CW2, testified that their late father, Alhaji Fatai Ashiri Abu Shueton, purchased the disputed property in 1987 as evidenced by the deed of assignment, CW2B. The vendors are the 4th, 5th, and 5th defendants who did not defend the suit. Exhibit CW2HI establishes ratification by the Olagbaji and Ojo families. The defendant's evidence. The defendant's exhibits DW3A1 to 5 and letters DW3BD lack probative value. The allegations by DW3 that Chief Musedilu Palola was not the head of the Akongo family in 1987 is not supported. The defendants did not provide sufficient evidence. Oh, am I muted? Okay. Am I muted? Can you hear me?
So we can hear you, ma.
Okay. The defendants did not provide sufficient evidence to refute the claimant's claims. The exhibits admitted from DW3 showing postal service receipts, that is DW3A125, do not hold any probative value concerning the claims before the court. Additionally, there is a letter dated 24 June 1990, DW3B, on Prince E.A. Oke's letterhead, headed paper, addressed to Kazim Dende regarding unspecified land. Exhibit DW3C, signed by A.A. Dende for the Ariku Akongu family, is dated 11 February 1992, whilst Exhibit DW3D, dated 13 December 1989, was signed by Chief Mase Falola Akongu Ovota, Madam Alake Dada, Mr. Fasai Karim, Aziz Dende, Badebo Dada, and Ebelem Taiwo concerning an unrelated transaction with Hong Kong Synthetic Fiber Co. Limited. All these letters are dated between 1989 to 1992. The deed of its assignment relied on by the claimant is dated February 1987. The allegations by DW3 that Chief Musedilu Falola was not the head of the Akongu family as at February 1987 is unproven, with no evidence presented to support this assertion. The pleadings and evidence of the claimant are solid and consistent regarding how the predecessor in title purchased the land in 1987 and subsequently ratified the purchase with the Olagbayi family. The defendant's case does not provide any ground to overturn the clear and consistent evidence presented by the claimant. Moreover, aside from the third defendant, the defendants did not present evidence to refute the claimant's allegations despite the serious nature of the allegations. Civil cases are decided based on the balance of probabilities, even in claims involving declaration of title to land. This principle requires the plaintiff to produce sufficient and satisfactory evidence to support their claim, thereby proving that they have a better title than the defendant. This standard applies consistently with the burden of proof remaining with the plaintiff throughout the trial. Where the plaintiff's evidence is adequate and the defendant fails to provide counter evidence, the court will decide the case based on minimal proof, or the minimum of proof. Now, I will be quoting from the case of Adeleke and Iyano, citation provided, where the Supreme Court, the apex court held, and I quote copiously, "It is a principle of law that civil cases are generally decided on the balance of probabilities, a standard that also applies to actions for declaration of land. As articulated by this court per Ibekwe, JSC in Kajola and Egula, citation provided, the court has always held that what is required of a plaintiff in an action for declaration of title is at least to establish his claim by a preponderance of evidence. It is often that he has produced sufficient and satisfactory evidence in support of his claim. The test is whether the plaintiff had been able to prove to the satisfaction of the court that he has a better title than the defendant, Akpan and Koke cited, and a host of other cases that followed it. The standard of proof in a claim of declaration of title is not different from what is required in civil cases generally. The only difference, if we may say so, rests on the fact that the burden of proof is on the plaintiff who is claiming title and that it never shifts to the defendant throughout the trial. That difference, therefore, lies not in the standard of proof, but on the burden of proof. This burden of proof involves using an imaginary scale to determine which side the evidence favors. Where the plaintiff has presented admissible evidence that is satisfactory within the context of the case and none is available from the defendant, the case will be decided upon a minimum of proof, thereby making the burden lighter. That is Adeleke and Iyano. The claimant's case is decided on minimal proof as the defendants have not adduced sufficient evidence in rebuttal. None of the defendants, except the third defendant, gave evidence, and the third defendant was unable to provide credible evidence to persuade the court against the claimant's strong documentary evidence and acts of possession, such as the building of the 7 shops and the additional 10 shops on the premises. DW3 testified that Olagbaji Ijobo family were customary tenants to the Akongo family, but failed to show any proof of this assertion. It did not prove that the Akongo family received tributes from the Olagbaji family as customary tenants as required in Abioye and Yakubu citation provided. The rendition of the Olagbaji history by DW3 holds no weight since it is from the Akongo family, yet it could not account for its history. On the issue of general and special damages, the claimant proved that the defendant destroyed the shops on the premises and sold the land to one Mrs. Famewa or Fabumi. We'll check if that is an error. The claimant specifically and strictly proved the damages and is entitled to compensation. The law is settled that where a plaintiff has suffered specific losses to income in addition to general damages for trespass, they can claim these specific losses as special damages. As stated in Uber and Samba Petroleum citation provided, this court held that both special and general damages can be awarded for trespass without resulting in double compensation. In Odiba and Azege, citation provided, this apex court stated that the law is firmly settled, established that where in a trespass action, general damages are claimed and established, it is the duty of the trial court to assess, quantify, and award the appropriate amount it considers reasonable. Where additional special damages are pleaded, claimed, and strictly proved, this will also be awarded to the claimant. That is the case of the Controller of Prisons and Elima citation provided. Sufficient proof exists that the claimant's shops were destroyed. The claimant is therefore entitled to both special and general damages for the trespass. I am satisfied that the claimant has proved their case through credible documentary evidence and acts of possession, and the defendant have not provided sufficient evidence in rebuttal. And I hold as follows. The claimants are entitled to the relief sought. I hold that the claimants are entitled to the statutory right of occupancy over the plot of land situated at Idiroko Road, Iyana Iyesi Ilupeju, Ota, as described in Survey Plan LAKS OG 94306, dated 21st of August 1994, and the sum of 775,000 is hereby awarded as special damages to the claimants for items and materials destroyed on the land by the defendants. The sum of 250,000 naira is also awarded as general damages for trespass to the claimants for acts committed on the land by the defendants. An order of perpetual injunction is granted, restraining the defendants, their servants, privys, and agents from committing further acts of trespass on the land in dispute. That is the judgment of the court.
As court pleases me, Lord, we are most grateful for the well-delivered judgments. We thank the Honorable Court for the patience and the industry in the judgments, and we pray for more wisdom on your Lordship. Most grateful, my Lord.
Right. You may exit, Mr. Akolawole.
Most grateful, my Lord.
Right.
Most grateful, sir.
Um, 1 minute, please. I will take a break and then go on to the matrimonial.
As the court pleases.
Right. Can we get back on?
Yes, my lord. Number
Please
2
call
on
the
the
next
cost.
date.
Yes,
Yes.
sir. ACS 528-2023. Mrs. Oluwatosin Tesi Araba. Mr. Ivan Otobulem.
With profound humility to your lordship,
1 minute, please.
as the court pleases.
Oluwatosin.
Tesi Araba.
Parties?
My lord, parties absent, sir.
Representation?
With profound humility to your lordship. My name is S.
I've lost you. I can't hear you very well, Leonard Counsel. I can't hear you, Leonard Counsel. For one thing, you should not be in a car. If you are to be heard virtually, you should not be sitting in a mobile car. He's not here. Can we go on with the next one and we'll get back to him?
Yes, my lord. Number 3 on the cost, sir. ACS 534-2023. Mr. Obichuku Darlington Elua. Mrs. Anna Love Elua.
Is the counsel in court for this one?
No, sir.
The others are not here?
They are
So
not, sir.
we have only counsel for the
For the fourth case, sir.
The counsel for Arabambulam, is he here now or is still absent?
He's not yet here, sir. He's absent, sir.
Okay, can we take the other one then?
Yes, my lord. My Lord, number 4 on the cost list, sir.
Right.
ACS 331-2022. It is Nkechi Onyinye Edebiatu. Mr. Ubaka Ndubusi Edebiatu.
If we are not attending to you, please mute yourself. You can only be on mute if your case is called, please. HCS 331.
Yes, my Lord, 2022.
Respectfully, my lord, Olusheye Demoren.
Can you please wait?
Oh, I'm sorry, my lord.
One minute, please.
Yes, my lord.
Nkechi Onyinye Edebiatu.
Yes, my Lord.
And Mr. Ubaka
Ndubusi Edebiatu, sir.
Ndubusi Edebiatu. Parties? Any of the parties online?
No, sir.
Representation?
Yes, respectfully, my lord, Olusheye Demoren. Announce my presence for the respondent, my lord.
What's your location today?
Lagos State, my lord.
Judgment. In the case of the petitioner Nkechi Onyinye Edebiatu and the respondent Ubaka Ndubusi Edebiatu. The petitioner presented a petition before this court on the 2nd of June 2022 against the respondent Ubaka Ndubusi Edebiatu for dissolution of the marriage contracted at the Federal Marriage Registry, Lagos State on the 14th of March 2012 on the ground that the marriage has broken down irretrievably. The respondent filed an answer and cross petition dated 7th July 2023 on pages 26 to 32 of the case file. The parties filed the following report of compulsory conferences. Report of compulsory conference of the 29th of September 2023, filed on the same day. Report of compulsory conference held on the 1st of July 2024 and filed on the 2nd of July 2024. Particulars of the parties. The maiden name of the petitioner is Okeke. The petitioner's given date of birth is 7th February 1981, whilst the respondent's given date of birth is 8th December 1981. The petitioner, a businesswoman, resides at 92 Femi Kila Street off Agopalas Way, Okota, Lagos State, Nigeria, whilst the respondent resides at 42 Akiwumi Street, Mende, Maryland, Lagos State. Both parties are within the meaning of the act, domiciled in Nigeria. There is a child of the marriage named Ariela Kosimasichukwu Edebiatu, female, born on the 6th of October 2012. She lives with the petitioner. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage in paragraph 10 of the petition. The petitioner seeks dissolution of the marriage on the ground that the parties have lived apart for more than 2 years preceding the presentation of the petition, and the respondent does not oppose dissolution of the marriage. The petitioner's prayers are for a decree of dissolution of the marriage and continuous custody of the child named Ariela Kosimachukwu Edebiatu. The respondent pleaded circumstances and facts leading to the breakdown of the marriage in paragraph 1 to 4 of the answer and paragraph 15 of the cross petition. The cross-petitioner seeks dissolution of the marriage on the grounds that the parties have lived apart for a continuous period of 3 years immediately preceding the presentation of the petition. And the orders sought by the respondent are as follows: an order dismissing the petition, a decree nisi of dissolution of the marriage on the ground that the marriage contracted on the 29th March 2012 at the Federal Marriage Registry for Lagos State, Nigeria, between the parties has broken down irretrievably on the following grounds: that the petitioner has since returned the bride price since sometime in 2018, and the parties have lived apart for a continuous period of 3 years immediately preceding the presentation of the petition. An order of custody of the only child of the marriage, Ariela Kosimachukwu Edebiatu, to the petitioner and the cross-petitioner shall be granted unfettered access to the only child wherever he is in Nigeria unsupervised, and the child shall spend part of her vacation with the cross-petitioner. Evidence of the petitioner. The petitioner gave evidence that she resides at 92 Femi Kila Street, Agopalas Way, Okota, Lagos State. She testified that the respondent is her husband and they got married on the 29th of March 2012 at the Federal Marriage Registry. The certified true copy of the marriage certificate was admitted as PW1A. There is a child of the marriage named Ariela Kosimachukwu Edebiatu and born on the 6th of August 2012. She lives with the petitioner. The petitioner testified that both parties cohabited cohabited after the marriage and at 42 Akinwumi Street, Mainde, Maryland. Again, the respondent suggested that they should end the relationship and her parents returned her bride price to the respondent's parents. She testified that she did not connive or collude to bring the petition. Under cross-examination, she admitted that the bride price was returned. She confirmed that the parties and counsel held a compulsory conference, which was reduced into the writing and files. She admitted that the respondent should be granted right of access and visitation as agreed, and that the child can spend time with the father. The petitioner urged the court to adopt the report of compulsory conference held on the 1st of July 2024 and filed 2nd of July 2024. The respondent did not give evidence. Learned counsel for the petitioner, Olusheye. Are you for the petitioner or for the respondent?
For the respondent, my lord. Respondent.
Okay.
Yes, my lord.
Learned counsel for the respondent, Olusheye Demori, Esquire, addressed the court and submitted that the marriage has broken down irretrievably pursuant to 15(2)(f) of the Act, as the parties have lived apart for 3 years. The petition was filed on the 2nd of June 2022, and cohabitation ceased on the 13th of March 2013. He submitted that the bride price was returned on the 5th of July 2017. The learned counsel urged the court to incorporate the report of the compulsory conference filed on the 2nd of July 2024 as the judgment of the court. It is tried that the petitioner or respondent who has presented a petition or cross-petition before the court that the marriage has broken down irretrievably under 15(1) of the Act must be able to bring himself within one or more of the facts stipulated in 15(2)(a) to h. For the benefit of the parties, I have reproduced in the body of the judgment the whole of 15(1) and 15(2)(a) to h of the Act. Also, in the case of Olorunfemi and Olorunfemi citation provided, the court held that the petition for dissolution may be presented upon the ground that the marriage has broken down irretrievably under 15(1), only if one or more of the facts in 15(2) is proved to the reasonable satisfaction of the court. So the case of Anioke and Anioke citation provided, see Akinlolo and Akinlolo citation also provided. The burden therefore lies on the person who will fail if no evidence is given on this side pursuant to section 131 and 132 of the Evidence Act, as cited in the case of Nwankwo and Nwankwo citation provided. where the court held that the standard of proof is settled by section 82(1) and 2 of the Act, which states that for the purpose of this Act, a matter of fact shall be taken to be proved if it is established to the reasonable satisfaction of the court, and where a provision of this Act requires the court to be satisfied of the existence of any ground of fact or as to that other matter, it shall be sufficient if the court is reasonably satisfied of the existence of that ground of fact or as to that other matter. The petitioner pleaded and testified that cohabitation between the parties ceased on the 13th of March 2013 due to the fact that the respondent relocated abroad to study and the parties have not resumed cohabitation since then. The petition was filed on the 2nd of June 2022. Bride price was refunded on the 5th of July 2017. The petitioner testified that their union ended when the respondent suggested they end the marriage. From the facts and evidence before the court, both parties have lived apart for over 3 years. The evidence of the petitioner on the ground that the marriage has broken down is satisfactory and in line with Section 15(2)(f) of the Act. Where 15(2)(f) is proved, the court may dissolve the marriage without fault finding. See the case of Omotunde and Omotunde, where the court held that the law is that the provision is mandatory and the court has no discretion to exercise. The section has the absence of the fault element, which is characteristic of matrimonial offenses. The law behind 15(2)(f), as far as living apart is concerned, is not interested in right or wrong or guilt or innocence of the parties. Once the parties have lived apart, the court is bound to grant a decree per Adikeye JCA at pages 62 to 63. Also see the case of Ajidaun and Ajidaun citation provided. I find 15(2)(f) proved by the petitioner against the respondent. Where 15(2)(f) is proved, the court will not go on a voyage to find fault as to matrimonial offenses pleaded, or as the fact of living apart is sufficient for the court to hold that the marriage has broken down, and I find it so. On the issue of custody, the courts are guided by Section 71(1) of the Matrimonial Causes Act, which provides that in proceedings with respect to custody, guardianship, welfare, advancement, or education of the child of the marriage, the court shall regard the interests of those children as the paramount consideration, and subject thereto, the court may make such orders as it thinks proper. Also see the case of Uduchi and Uduchi, where the court held that in deciding the issue of custody, the court must take into consideration the ages of the children, education, welfare, general upbringing, arrangement for accommodation, and the conduct of the parties. Indeed, the interests of the children at all times should be of paramount consideration per Rules Bible JC at pages 20, paragraph C to G. Also see Alabi and Alabi, citation provided, where the court held that the welfare of the child is paramount, and the degree of familiarity with parents ought to be taken into consideration. The court will also consider the ages of the children. See the case of Udugu and Udugu citation provided. If the parents are separate, where the court held that if the parents are separated and the child is of tender age, it is presumed that the child will be happier with the mother, and no order will be made against this presumption unless it is abundantly clear the contrary is the situation, e.g. immorality of the mother, infectious disease of the mother, insanity, and or cruelty to the child. The means and incapacity conduct and all relevant circumstances of the case will also be considered. See Nana and Nana. The child of the marriage, Ariela Kosi Machuku Edebiatu, born on the 6th of October 2020, she is a minor. She's of tender age. The respondent, who is her father, must take the responsibility of caring for the child's education and welfare. All hands must be on deck to ensure that the educational needs and welfare of the child is taken care of. The court will make the appropriate orders, taking into consideration the total circumstances of the case. On the totality of the evidence before the court, I hold that the petitioner has proven our case pursuant to 15(2)(f) of the Act to the reasonable satisfaction of the court, and I make the following orders. A decree NISA is granted, dissolving the marriage solemnized between Nkechi Onyinye Edebiatu and Ubaka Ndubusi Edebiatu at the Federal Marriage Registry, Kogi, Lagos State, on the 29th of March 2012, Nigeria. The decree NISA shall become absolute 3 months from today if there is no contrary order of the court. Pursuant to the report of compulsory conference held on the 25th of January 2023 and 19th June 2024 and filed on the 2nd of July 2024, the court hereby orders as follows. The petitioner shall continue to have custody of the only child of the marriage, and she shall continue to reside with the petitioner until she attains the age of 18 years, when she can decide to stay with either of the parents. The respondent shall be solely responsible for the academic fees of the child per term or per session up to university or tertiary level of education. School fees shall be paid on or before the first day of resumption. The respondent shall pay a monthly allowance of 50,000 naira for the welfare and maintenance of the child of the marriage. The respondent shall pay same into an account to be opened in the name of the child and dedicated for that purpose. The petitioner shall be entitled to, the respondent shall pay the same into a dedicated account, not necessarily in the name of the child, shall pay into a dedicated account for the benefit of Ariela Edebiatu. Let me just correct that. The respondent shall be entitled to visiting rights for the child of the marriage. The petitioner shall make the only child of the marriage available to spend unsupervised time with the respondent wherever he is in Nigeria. The child shall spend weekends once every 2 months with her paternal grandparents. The first 2 weekends shall be supervised and also unsupervised whenever the respondent is in Nigeria. The consent of the respondent shall be obtained before the petitioner can take the child out of the country. Such consent shall not be unreasonably withheld by the respondent. The court hereby orders that whenever the child travels outside the shores of Nigeria and is in the same country with the respondent, she shall spend half of her vacation period with the respondent, provided that the respondent contributes to travel expenses of the child. The court hereby orders that in the event that the child relocates to a country where the respondent is resident and the petitioner is not resident therein, then the respondent shall have custody of the child until the petitioner is present in the country where Ariela is resident. How many of these? Right. I hope that is what.
Yes, my lord.
Right. The respondent, just want to be sure about that, shall grant the petitioner unfettered access through all means of communication under this condition, that is by telephone, video call, email, Zoom, WhatsApp, or any other mode of communication. The respondent shall pay all medical expenses of the child of the marriage in the event of sickness or subscribe to a health management organization for the health needs of the child. The petitioner, on the other hand, shall continue to take care of the accommodation of the child as part of our own contribution, in addition to looking after the child in our primary custody. Both parties shall maintain peace and provide a conducive atmosphere for the growth of the child. If the respondent fails to fulfill his obligations under paragraph 6 to 8 above, he loses his rights of access to the child until the obligations are fully met. any of the parties may apply for an upward review of the maintenance sum where circumstances change pursuant to Order 73 of the Matrimonial Causes Act, Laws of the Federation 2004. That is the judgment of the court.
My Lord, we're most grateful for the well-considered ruling, my Lord.
Right.
Thank you, my Lord.
Right. You may exit if you wish.
As the court pleases. I'm most grateful, my Lord.
Right. B 3B, C, 3B and C. Three B, C, and I. Right. Do you want to call the next one? It's everywhere. Shalewa, are you still there? Shalewa? Have I lost you? Please call the next case. Is Mr. Stephen ready now? Please have your seat, Mr. Muiwa.
Yes, ma'am.
You must be within camera view. Yes.
My Lord, the next one.
Number 1 on the cost list, sir.
Yes.
ACS 528-2023. Mrs. Oluwatosin Tesi Araba. Mr. Ivan Otobulem.
Parties?
Parties absent, my Lord.
Representation? Representation?
Mr. Stephen, on your video.
My lord is there, but we don't know what happened. He's not saying anything. Maybe it's the
Present
network.
counsel, Mr. Stephen. Can you announce your appearance?
He's gone again.
We'll go on with the judgments.
As God pleases, my lord.
The petitioner, Oluwatosin Tesi Araba, petitioned the court, presented a petition for dissolution of the marriage contracted with Ivan Otobulem, the respondent, on the 18th of September 2019 at the Federal Marriage Registry, Ikoyi, Lagos State, on the ground that the marriage has broken down irretrievably. Particulars of the parties. The maiden name of the petitioner is Araba. The petitioner was born on the 22nd of September 1991 in Nigeria, whilst the respondent was born on the 1st of February 1992 in Lagos State. The petitioner, an IT consultant, resides at 60 Avenue, Dr. Etibok, Ontario, Canada, whilst the respondent resides at Plot 405 Cadastral Zone B13, Gaduwa District, Abuja, FCT, Nigeria. Both parties are within the meaning of the act, domiciled in Nigeria. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage in paragraph 8 of the petition. There is no child of the marriage at the time this petition was filed, and there is no property jointly owned by the parties. The petitioner seeks dissolution on the ground that the parties have lived apart for 3 years immediately preceding the presentation of the petition. And there is no hope that the parties will live together ever again. Evidence of the petitioner. The petitioner testified that the respondent is a Nigerian and her husband. Parties got married on the 18th of September 2019 at the Federal Marriage Registry, Ikoyi, Lagos State. The marriage certificate earlier submitted before the court was screen shared. Identified by the petitioner and admitted as PW1A. Petitioner testified that the parties cohabited at 36 Abba Macaulay Way, Yaba, Lagos State, from the 18th of September 2019 to the 20th of July 2020, when cohabitation ceased. She testified that she relocated to Canada for over 3 years now, and she does not have any intention to live with the respondent again, as their marriage has broken down irretrievably. There is no love between the parties anymore, she said. The petitioner gave evidence that the union did not produce a child and she did not connive or collude to bring the petition. She urged the court to dissolve the marriage as the parties have lived apart for over 3 years. The petitioner urged the court to dissolve the marriage as there is no previous proceedings between the parties. Learned Counsel S.I. Azubike Esquire addressed the court and submitted that the marriage has broken down irretrievably pursuant to 15(2)(f) of the Act, as the parties have lived apart for 3 years. He also cited the case of Omotunde and Omotunde citation provided. In matrimonial proceedings, the petitioner who seeks the order of the court to dissolve the marriage on the ground that it has broken down irretrievably pursuant to 15(1) must be able to bring himself between one or more of the facts stipulated in 15(2)(a) to h, which is reproduced in the body of the judgment. Also see the case of Ibrahim and Ibrahim, where the court held that the burden is on the petitioner or cross-petitioner to give credible evidence to the reasonable satisfaction of the court. The petitioner must therefore plead and prove one or more of the facts stipulated in 15(2)(a)(h) of the Act. See the case of Ikrebe and Ikrebe citation provided, see section 82(1) and 2 of the Matrimonial Courts Act, which is also reproduced in the body of the statement. The petitioner testified that cohabitation ceased on the 28th of July 2020. She has been in Canada for over 3 years and she has no intention to resume cohabitation with the respondent. The petition was filed on the 19th of February 2023. This is over 3 years that the parties have lived apart. The evidence before the court is that is satisfactory and in line with the pleadings and 15(2)(f). Cited the case of Omotunde and Omotunde once again, and the dictum of Adekeye JCA, where his lordship said that the law is mandatory and the court has no discretion to exercise, where 15(2)(f) is where the section has the absence of the fault element, and it is not interested in right or wrong or guilt, innocence of the parties. So I find 15(f) proved by the petitioner against the respondent, and on the totality of the evidence, I'm satisfied that the petitioner has established the irretrievable breakdown of the marriage pursuant to 15(2)(f). A decree nisa is granted, dissolving the marriage solemnized by the parties at the Federal Marriage Registry on the 18th of September 2019. The decree nisa shall become absolute 3 months from today if there is no contrary order of this court. That is the judgment of the court. Registrar, are you there? Are you there, Registrar? Can you call the last case?
ACS 534/2023, Mr. Obishuku Elua, Mrs. Anna Elua. My lord, parties are present, absent, my lord.
Right.
Yes, my lord.
One minute, please. Did you call counsel in this one?
Yes, my lord. I even sent message to him, my lord. Even I spoke with him as well this morning, my lord.
Right. What's the name of the counsel?
SS Shitu, my lord. SS Shitu, my lord.
Judgment in the case of Edua and Edua. The petitioner, Obichukwu Darlington Edua, presented a petition before this court on the 28th of February 2023 for dissolution of the marriage contracted with the respondent, Anna Love Edua, on the 5th of November 2011 at the Federal Marriage Registry, Kogi, on the ground that the marriage has broken down irretrievably. Particulars of the parties. The maiden name of the respondent is Dodo. The petitioner was born in Lagos State on the 28th of October 1982, whilst the respondent was born in Ghana on the 22nd of June 1989. The petitioner's given address is 15 Apowodo Street, Pedro, Bariga, Lagos State, whilst the respondent's given address is 46 Adaranejo Street, Pedro, Palm Group, Lagos State. The parties are within the meaning of the Act, domiciled in Nigeria, as the petitioner has not stated another domicile except Nigeria. There are 3 children of the marriage named Jasmine Edua, one on the 11th of November 2012, Jacqueline Edua, one on the 9th of November 2014, and Jaziel Edua, one on the 11th of September 2018. They live with the petitioner. The petitioner's proposed arrangement for the children is stated in paragraph 8123 of the petition. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage in paragraph 8 of the petition. There is no property jointly owned by the parties. The petitioner seeks dissolution of the marriage on the grounds that the parties have lived apart for 3 years, immediately preceding the presentation of the petition. Evidence of the petitioner. The petitioner, Obichukwu Darlington Edua, a hotelier, gave evidence, strong evidence that he resides at flat H, Carrington Court, Millerton, Lekki, Lagos State, Nigeria. He is a human resource practitioner. The respondent, Anna Love Edua. One minute, please. The respondent, Anna Love Edua, is his wife. Parties got married on the 5th of November 2011 at the Federal Marriage Registry for Lagos State. The marriage certificate was admitted as PW1A. It testified that parties cohabited after the marriage at 40 Adarayo Street, Pedro, Bariga, Shomolu, Lagos State. There are 3 children of the union, which I have named earlier. Cohabitation ceased on the 10th of August 2019 when the petitioner left the matrimonial home. The children are in the custody of the respondent. The petitioner testified that parties have irreconcilable differences and several marital conflicts. They also had issues of physical and verbal abuse for a long time. He testified that parties share the upkeep, but he single-handedly pays the school fees of the children. He testified that the parties agreed to jointly pay for their upkeep. He urged the court to grant him unfettered access to the children. The petitioner urged the court to dissolve the marriage. All processes were duly served on the respondent, but she did not defend the petition and did not give evidence. One minute, please. 1 minute, please. Learned Counsel SSG2 Esquire addressed the court and submitted that the marriage has broken down irretrievably pursuant to 15.2F of the Act, as the parties have lived apart for over 3 years preceding the presentation of the petition. In matrimonial proceedings, the burden is, of course, on the petitioner to give credible evidence subject to Section 82(1) and 2 of the Act, which is reproduced in the body of the judgment. The court places a heavy burden on the petitioner, which he must discharge, even where the petition is undefended. See Uzokwe and Uzokwe citation provided. Well, I have cited that in the first place, the burden of proof in matrimonial proceedings is on the petitioner, as ordered by Section 135 and 136 of the Act. Damaluk and Damaluk, Nana, Ibrahim and Ibrahim, Muela and Muela all relied on. As for the standard of proof, it is decreed by the presumption of Section 82 of the Act. The petitioner or cross-petitioner, therefore, who seeks the order of the court to dissolve the marriage on the ground that it has broken down pursuant to 15.1, must bring himself within one or more of the facts stipulated in 15.2A to H, which has been reproduced copiously in the body of the judgment. Also see the case of Bakari and Bakari, where the court held that a court cannot dissolve a marriage or declare the marriage to have broken down irretrievably unless one of the listed facts is proved to the satisfaction of the court. The petitioner relies on 15.2F. It testified that cohabitation ceased in 2019 on the 10th of August precisely. The petition was filed on the 28th of February 2023. The evidence clearly shows that the parties have lived apart for over 3 years. The evidence on the ground that the parties have lived apart is satisfactory and in line with the pleadings on 15.2F. Where 15.2F is proved, the court will not go on a fault-finding expedition. See the case of Omotude and Omotude for that, as there is no discretion for the court to exercise under 15.2F as far as living apart is concerned. Once parties have lived apart, the court is bound to grant a decree. See the case of Ajidan and Ajidan also. On the issue of custody, the courts are guided by Section 71 of the Act, which I have reproduced in the body of the judgment, and also the case of Udoche and Odoche, where the court will consider what is the paramount interest of the children. The court will also consider the ages of the children, the education, the welfare, the general upbringing, and the arrangement and conduct of the marriage. Indeed, at all times, the court must consider the paramount interest of the child of the marriage. See also the case of Alabi and Alabi, citation provided, and Ojogu and Ojogu. The court will also consider the age of the child. If the child is of tender age, it is presumed that the child will be happier with the mother, and no contrary order will be made, unless in the case of immorality of the mother, infectious disease of the mother, insanity or cruelty of the child. Also, the court will consider the means and earning capacity of the parties and all relevant circumstances. There are 3 children of the marriage. They live with the respondent. They are still of tender age, and the petitioner has given evidence that he has been single-handedly responsible for their education and other needs are shared with the respondent. The petitioner conceded custody to the respondent whilst he wants unfettered access. The court will give the appropriate orders subsequently on the totality of the evidence before the court and satisfy that the petitioner has established the irretrievable breakdown of the marriage pursuant to 15.2F of the Act. From the foregoing, I hold that a decree NISA is granted, dissolving the marriage solemnized between the parties on the 5th of November 2011 at the Federal Marriage Registry. Equally, Lagos states the decree NISA shall become absolute 3 months from today if there is no contrary order of this court. The respondent shall have primary custody of the 3 children of the marriage. The petitioner shall also have unfettered access to the children upon reasonable notice to the respondent one Saturday monthly. He shall make arrangements to pick the children up at 9 a.m. and return them back on 6 p.m. to the respondent's place of residence. On the same day, the petitioner shall have access to the children during the school term and holidays. Holidays shall be shared equally between the parties when they attain the age of, between the parties. It shall participate when they attain the age of 18 years. It shall participate in all school activities. The petitioner shall pay the school fees of the children of the marriage per term or per session up to university or tertiary level of education. The petitioner shall pay the sum of 100,000 monthly as upkeep and feeding for the children of the marriage. The petitioner shall pay all medical expenses of the children in the event of sickness or subscribe to a health management organization for the health needs of the child. The respondent on our own part shall continue to take care of accommodation and other maintenance of the children as part of our own contribution, in addition to looking after the children in our primary custody. Both parties shall maintain peace and provide a conducive atmosphere for the growth of the children. If the petitioner fails to fulfill his obligations if the petitioner fails to fulfill his obligations, he loses his rights of access to the children until all conditions are fully met. Any of the parties may apply for an upward review of the maintenance sum where circumstances change. That is the judgment of the court.
At copies, my lord.
Thank you
That's
very
all for today.
Yes, thank you very much, Mr. Muiwa and Shaliwa. Have a good holiday. I believe we don't have any other thing again until we resume in September.
Yes,
Okay,
my lord.
then. All right,
Thanks,
then.
my lord.
I will now exit. I will end the session now.
As
As
copies,
copies.
my lord.